The Sixth Amendment of the Constitution was ratified on December 15, 1791. It is part of the Bill of Rights. The Sixth Amendment gives one a right to a speedy trial. Get it? Speedy trial. Okay. Well, the Sixth Amendment was originally found in the Magna Carta. It's also important to note that persons in jail must be supported at considerable public expense, and often families must be assisted as well. Persons free in the community may commit other crimes, may be tempted over a lengthening period of time to jump bail, and may be able to use the backlog of cases to engage in plea bargaining for charges or sentences which do not give society justice. If I can spell society justice correctly, here we go. The Sixth Amendment also gives one the right to a public trial. Roots can be traced back to English law, as a general distrust of secret trials existed in Europe at the time, namely due to Spanish Inquisition. So essentially, this amendment safeguards against any attempt to employ our courts as instruments of persecution. In Waller v. Georgia, the court held that an accused's Sixth Amendment rights had been violated by closure of all 7 days of a suppression hearing in order to protect persons whose phone conversations had been taped when less than 2 hours of the hearing had been devoted to playing the tapes. That's not problematic, I don't know what is. In full, the Seventh Amendment reads, "In suits at common law, where the value in controversies shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law." The Seventh Amendment is part of the Bill of Rights, or the first 10 amendments of the Constitution, and they were all ratified on December 15, 1791. Let's apply the amendment to one of the most popular court cases surrounding the Seventh Amendment to create a situational understanding. In 1987, the United States filed a civil lawsuit against Edward Tull for discharging fill materials into wetlands in violation of the Clean Water Act. The court ultimately denied Tull's motion for a jury trial because it didn't have the qualifications to be a civil trial. The Court of Appeals affirmed the denial of a jury trial, and the Supreme Court granted cert. An online case summary about the Tull case reads, "In reversing and remanding the case for a jury determination of Tull's liability, the Supreme Court held that while the assessment of civil penalties after a finding of liability does not implicate the Seventh Amendment right to a jury trial, actions by the government seeking civil penalties and injunctive relief are analogous to suits brought to punish culpable individuals in suits at common law, and thus the determination of liability in such actions implicated the Seventh Amendment right to trial by jury. This means that Tull's offense, to be simply put, did not qualify him to have a trial by jury." Another way to understand the Seventh Amendment is knowing what each line means and how each line is important to the Constitution as a whole. The line, "In suits at common law, where the value in controversies shall exceed $20, the right of trial by jury shall be preserved," is a bit outdated, considering $20 is not much money anymore. Today, any disputes that involve amounts less than $75,000 will not be handled in a federal court. Essentially, this line states that any case that does not cost 1 year of college tuition shall not be considered in federal court matters. So, if you would rather dispute an issue in federal court instead of go to college, it is highly suggested you save up some cash. The next line reads, "And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. It basically states here that it is illegal for anyone to create their own court system. If someone goes to court, it must be recognized by the government for it to be valid. These courts are often city, country, state, or national courts. This amendment also gives one the right to have a trial with a jury, as was stated before. Before 1688, English judges were servants under the King of England. They were often biased towards the king. In turn, their rulings were not always fair. During the Act of Settlement in 1701, English judges won their independence from the king, but judges in the American colonies were still biased towards the king. King George III got rid of trial by jury, and that created upset among the people. So it was only natural that one of the amendments in the newfangled Constitution would include something that would allow the accused to have a trial with a jury and go against what the King of England wanted. Justice is served and King George III gets roasted.
The institution of the Eighth Amendment ensures that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted upon anyone within the United States. As part of the Bill of Rights, it was ratified on December 15, 1791. The overall intended purpose of this amendment was to safeguard Americans from unfair or unjust punishment based on any legal violation. The first part of the amendment concerns excessive bail. The purpose of bail is to allow those accused of crimes to avoid jail time before they're proven guilty. The money is collateral for their freedom, and it is returned at the time of their trial. In this sense, the concept of bail encourages defendants to attend their trial and regain the money they've sacrificed. Preventing excessive bail certifies that no man or woman shall be at an unreasonable disadvantage simply because of their financial circumstances. The amendment then addresses the idea of excessive fines. This simply prevents anyone within a court of law from imposing immoderate monetary demands on the accused, putting them in a precarious or inequitable financial position. Finally, the amendment certifies that no person within the United States shall face cruel and unusual punishment. Initially, this portion of the amendment was intended to prevent repugnant executions. Some examples of that are burning at the stake and the use of an electric chair. Over the years, interpretation of this segment has been expanded to protect men and women against unfair assessments of their wrongdoings based on personal circumstances such as mental illness. Furthermore, it has ensured that prisoners in public penitentiaries must be allowed conditions that satisfy a decent quality of life. One of the most controversial aspects of this amendment has been its application to cases that warrant the death penalty. Overall, the Supreme Court maintains that for federal crimes, the death penalty does not qualify as cruel or unusual punishment if it is performed in a particular way. The controversy over this amendment is evident in several court cases, particularly the case of Atkins v. Virginia in 2002. An 18-year-old named Darrell Atkins was found guilty of abduction, capital murder, and armed robbery. The courts felt it appropriate to consider the death penalty as a reasonable punishment for Atkins. Based on the investigation of a forensic psychologist, it was determined that Atkins was mentally retarded in some capacity. His interview with the psychologist, the testimony of his peers, academic records, court records, and an IQ score of 59 served as verification. Mental retardation often inhibits cognitive processes of reasoning, control of impulses, and the ability to make proper judgments. The court ruled that imposing the death penalty upon a man or woman that is mentally retarded qualifies as cruel and unusual punishment, violating the Eighth Amendment.